authorities capable of exercising authority over the first applicant to ensure that he abides by the conditions of bail in the event he is granted bail. The second applicant's relationship to his sureties as husband, father, and brother, respectively, notwithstanding. In my view, arguments the ability to compel him to comply with his bail conditions in the event that he is granted bail. It is enough that the sureties provided copies of their national identity cards and introduction letters from local council chairpersons of the areas where the sureties are ordinarily resident, as set out in paragraph 15 of the paragraph 15 to A and B of the bail constitutional guidelines for courts of judicature, class directions 2022. The aforementioned guidelines do not provide guidance on the format of the introduction letter should take and what it must state. Neither do they make reference to permanency of residence in terms of owning property as alluded to by the response. The declared relationship between the authorities as close friends presented by the first applicant arguments their suitability as sureties. Also, the declared blood relationship between the second applicant and his second and third sureties and the relationship of the first surety as the wife of the first applicant admits their suitability as sureties. Although, as one of the factors considered in determining the suitability of sureties, the bail guidelines mention age. It does not, in my view, indicate that the surety must always be older than the applicant. It is enough that the sureties are adults in positions of responsibility or so as so connected to the applicant that they are able to exert pressure on the applicant to comply with their bail conditions if granted bail. To say that a surety must always be older than the applicant is to set a dangerous precedent where senior citizens of very advanced age may never be granted, may never be able to find the sureties who are older than them. I therefore find that the first and second applicants have satisfied the requirements to present substantial sureties. Exceptional circumstances. It is settled law that existence of exceptional circumstances is no longer mandatory for bail to be granted, as bail can be granted even where there are no exceptional circumstances. Uganda vs. retired Colonel Dr. Kizza Besigye Supra. That proof of exceptional circumstances. The proof of exceptional circumstances is an application. That proof of exceptional circumstances in an application for bail is not mandatory. In this application for bail, however, the first and second applicants lie on the adverse age as their exceptional circumstances. Section 16, subsection 3, part C of the TIA provides that exceptional circumstances include the infancy or advanced age. There is no doubt that the applicants at 68 years, 65 years old, respectively, are of advanced age. The applicants have succeeded in proving exceptional circumstances in the context of Section 16, subsection 3, part C of the TIA. In this case, the applicants have proved that they have a fixed place of abode, substantial sureties, are of advanced age. Both applicants have not been found guilty of any offense previously, while the first applicant has charges pending against him at Uganda Road Court. The second applicant has no other charges pending against him. The first applicant was released on bail in respect of the charges pending against him at Uganda Road Court by interpretation of the other charges against the applicant does not extend to charges in respect of which the applicant was released on bail and has not been proved that before he had deliberately or for no justifiable reason failed to abide by bail terms. Graft of the offense, nature of the offense, and possibility of delay of commencement of trial. As for the applicant cited the case of Makoha, Samuel, and 35 others versus Uganda, where the applicants were granted bail while being charged with terrorism, contrary to Section 6, subsection 1b, and Section 2, and subsection 2, part B of the Anti-Terrorism Act. It was submitted for the response that the applicants in this case of Makoha, Samuel, and 35 others versus Uganda Supra are charged with terrorism, which attracts life imprisonment on conviction, while the applicants in the present case are charged with treason, which attracts a sentence of death upon conviction. I am persuaded that on the scale of gravity, the charges against the applicants in this case attract the ultimate penalty and therefore are graver than the charges against the applicants in the case of Makoha, Samuel, and 35 others versus Uganda. While the charges in both cases are grave, the charges in the present case, the present application, are more serious. As for the applicants, stated that the International Crimes Division of the High Court held in granting the applicants bail in the Makoha case said that despite the gravity of the allegations against the applicants, this court must determine whether sufficient evidence is presented to indicate the guilt or innocence of the applicants. In that case, the prosecution stated in their affidavit in opposition of the application that there was sufficient evidence against the applicants. In the present application, the respondent has stated that the investigations are still ongoing and has not made any assertions about sufficiency of the evidence against the applicants, basing on the evidence so far adduced. This court is therefore unable to make a determination on the sufficiency of evidence pointing to the guilt or innocence of the applicants. In Uganda, DPP versus Kano, retired Dr. Kizza, Besigye, motion reference number 20, it was stated that in relation to bail, the extent to which evidence is pointing to proof of guilt or innocence of the applicant would seem to be one of degree in circumstances of a particular case. Counsel for the applicant in support of the affirmation that the offense impacts on the national security of Uganda. It was added that the investigators have pledged nothing before this court to suggest that there is evidence of any nature at all of this, suggests that what they aver. And their response to this point, as for the response submitted that the charges with which the applicants are charged, treason, involves violent change of government. I am inclined to side with the respondent that treason being an offense that involves overthrowing government, which act is accompanied by violence, an act of treason impacts on national security of Uganda. Possibility of interference with investigation and witnesses. It was submitted for the applicant that there is no likelihood of the applicants interfering with the witnesses. As for the applicant cited Bantu versus Ara, 1973, at page 282, where it was held that Allegations of interference with the witness must be substantiated. That such substantiation is not difficult to show. In reply, as for the respondent submitted that the first applicant is a prominent and influential person, and the second applicant is his personal assistant. That in releasing them on bail, will accord them the opportunity to interfere with witnesses and investigations which are still ongoing. As for the respondent, on the case of Okello Augustine versus Uganda, application number 6 of 2012, where the court emphasized that once the likelihood of abscondment and interference with investigations have been established, the court should be hesitant to grant bail. In this case, the respondent said that the applicants are very influential people with the ability to interfere with investigations. Although the respondent has not gone ahead to say in detail how the applicants are likely to interfere with the investigations which are ongoing, the particular circumstances of the case against the applicants must be borne in mind. The offences are said to have been committed in various jurisdictions, and the charges are extremely grave. I agree with the respondent that the applicants are very influential people with the wherewithal to interfere with the likelihood to interfere with the investigations which are still ongoing. Decision. The main consideration for bail for release of an accused person on bail are the right to liberty and presumption of innocence. Article 23 of the Constitution provides that no person shall be deprived of personal liberty of the court, whether established for Uganda or another country or of another international court or tribunal in respect of a criminal offense on which that person has been convicted or of an order of court punishing the person for contempt of court. Article 28 3A of the Constitution provides every person who is charged with a criminal offense shall be presumed to be innocent until proven guilty or until that person has pleaded guilty. Article 23 of the Constitution, in recognition of the fact that liberty may be curtailed even where the sentence or order of the court is pending, provides that where a person is arrested in respect of offense, the person is entitled to apply the court to be released on bail, and the court may grant that person bail on such conditions as the court considers reasonable. Article 23(6) of the Constitution entitles accused person to apply for court to be released on bail. It is clear from Article 23(6)(a) of the Constitution that accused persons, in respect of the grant of the offense, are entitled to apply to be released on bail. However, the discretion remains with the court to grant or reject the application for bail. See Uganda versus Kano, retired Dr. Kizza, Besigye. Constitutional reference number 20 of 2005. Among the considerations for purposes of this question is the gravity of the offense. Courts will be more readily courts will more readily grant bail or less for less serious offenses than the serious offenses. The offense will as in the case of Okello Augustine versus Uganda, Supra, while acknowledging the release of an accused person on bail is premised on the right to liberty, there should be peace and safety of the people and their property. The court of law and all other organs of government have a duty to ensure that national and international security is preserved. Therefore, the fundamental rights of the individual must be balanced with this greater public interest. In this regard, court has to consider whether there is justification to interfere with the accused person's right to liberty when his or her trial. The circumstances of the present case are that it is alleged that the offences were committed by the accused persons in various jurisdictions, including Kenya, Greece, Belgium, and Netherlands, with other persons still at large. The investigation into the charges against the applicants have been included by the fact that the offences are alleged to have been committed in various jurisdictions. These are unlikely to be wrapped speedily as investigations in special offences are to be committed only in Uganda. It was argued for the applicants that their continued incarceration, while investigations which do not have a clear timeline of conclusion are ongoing, is prejudicial to them, and it is not clear when the investigation will set the meeting of the applicants for trial the High Court. Counsel for the applicants said that there will be therefore this substantial delay in if the person has been managed in custody for 180 days before the case is court. I am of the opinion that this provision takes into account that the circumstances of this case, where one reason or another investigation cannot be concluded speedily, it's on the time and the time on demand without coming to beyond which time attained. Have substantialities of advanced stage and are of first time offenders, since they have never been convicted of any criminal offense. It has also not been proved that on a previous occasion, the applicant did not abide by the conditions. While the first applicant has charges pending against him at Uganda Road Court, for which he was released on bail, the second applicant has no charges pending against him. As cited in John Muhango's Kashaka versus Uganda, the background and the background where the alleged as a offense. In young then John versus Uganda, what to appeal of Uganda is in 2013. It was stated that the granting of bail by court to one before court is essentially one before court is justice and law. Therefore, although I find that the applicants have satisfied all the relevant requirements for grant of bail, such as proving that they have fixed places of abode, have substantial sureties, and first offense Offenses are alleged to have been committed in stations in Uganda and in other countries where more time and resources the case in offenses alleged to have been committed only in Uganda. What is that rule?